Paul, on the first Monday in October of 1990, yes, the Supreme Court, agreed to hear the case of Jeffrey Mason versus the New Yorker. Alfred A. Knopf and Janet Malcolm not to rule on the question of whether quotations had been altered or fabricated, but to decide if, should a jury find they had been, those alterations had been made with reckless disregard for the truth. First Amendment advocates were dismayed. It is a monumental step back, complains prominent attorney Martin Garbus. It gets rid of 35 years of libel law. Oh, look at the Supreme Court of the United States. Delivered its opinion on June 20th of 1991. Justice Anthony Kennedy, yes, seemed to have Justice Kaczynski's libel checklist in the back of his mind. Now, a lot of people dislike these pictures that I put in emails. Yeah. But when I'm using a quote from the Peninsula Daily News, and you make me go through years of pain and suffering, completely ignoring the actual evidence that would have exonerated me, I think I have a real case here. Yeah. In fact, I think I can sue every judge in the United States of America. Now, I'm going to want to know who they are, and I want to know if they know. Because when the prosecuting attorney is quoted in the Peninsula Daily News as saying, well, I had to do it, I was obligated to do it. I think that I was obligated to make sure of the journalistic quality of the evidence. Now, I gave you some other evidence, and you didn't want to hear that either. See, I had to go to Jefferson County so they could dismiss the case. Yes, because I was found incompetent. But it was a case that should have never happened because you as a county would not exonerate me from what happened on December 31st of 2015. Peninsula Daily News. Let's see here. And Nichols said he was obligated to issue the January 25th notice under the U.S. Supreme Court case Brady versus Maryland. Poop. I just wanted to make sure that I quoted it correctly. The ruling requires law enforcement agencies, known as the Port Angeles Police Department, the Sequim Police Department, yes, the Port Townsend Police Department, to notify attorneys of potentially exculpatory evidence, information, in terms of the credibility of a witness, and for prosecuting attorneys to disclose the information to officers, most notably, Nichols said, to defense lawyers. Now, this quotation, yes, does it fit this Supreme Court case from 1990? Does it? Was it? Whether or not a defense attorney chooses to use that information is a determination best made by the defense. Now, I would have thought that my defense attorney, Bruce Hanafy, yes, once he had the evidence, yes, he would have immediately dismissed the case and I would have gotten my sons. False arrest, false imprisonment, false accusations, and the deception of my wife that did not sign the protection order. Now let's see. The ruling requires law enforcement agencies to notify attorneys of potentially exculpatory information. When interviewed, and I said I wasn't in Sequim, Washington, did anybody from any law enforcement agency in the United States of America contact the bus company to find out if I was on the bus at 7:47 a.m.? FBI, Homeland Security. Now, for every one of you that says that, well, we don't have to provide potentially exculpatory information, I would say that I could sue every attorney of the United States for violating their attorney oaths. And for those that might be employed from myself, yes, that doesn't mean that I can't sue them. Now, I was looking at that 6068. Oh, why don't you get me all the attorneys that are practicing and those that are not? Yes, that have signed an attorney oath when they joined the Bar Association in their various jurisdictions. Now, let me see here. Malicious harassment, introduction to hate law crimes, code section 6068. Let's look at what it actually says. Poach. Let's see here. Business and Professional Code section 6068. Now, was this from the Constitution of the state of California? Poach. Why don't you give me the attorneys in the state of California? Reversal judgment preceding this ethical conduct on the part of the prosecuting attorney. Yeah. The attorney oath. I solemnly swear or affirm that I will support the Constitution of the United States and the Constitution of the State of California. And I will faithfully discharge the duties of an attorney and counselor at law to the best of my knowledge and ability. Poop. Now, how many attorneys, to the best of their knowledge and ability, have any knowledge of what the prosecuting attorney explained in Brady versus Maryland? Attorneys. Now, it was so good that he was quoted in the Peninsula Daily News as saying that he had an ethical obligation. Yes, he did. It was an ethics issue that he just had. He was obligated to provide the exculpatory evidence. Poop, poop, poop. But the problem is, no one wanted to provide the. Oh, now we have ethics violations on the part of the attorneys of the United States of America. Give me all of those that have been in any bar association that happen to still be alive. I don't care if they're 95 fucking years old. Give me every attorney of the United States of America. Now, well, does anybody else know about this obligation on the part of attorneys? Yes, because to the best of your ability and knowledge, as I understand it, is not just for the prosecuting attorney's office. Obligated to issue the January 25th notice? Yes. Brady versus Maryland. State criminal rules on discovery. Rules of ethical conduct. Yes. I mentioned in some videos that I made Sunday morning. Yes, it was a Bible reading having to do with the Supreme Court rules of the United States. Now, these rules of ethical conduct right now, I will sue every fucking attorney.